All right, hello and welcome. Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. Thank you so much for being here. My name's Otis Landerholm, and I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Thanks so much for tuning in today to another episode of the Empowered Immigrant Live. Today our theme, our topic is it possible? Is it possible to get a green card if you have a DUI? All right, is it? So we'll talk about that, and thanks for joining our episode today. And as always, if you have questions, feel free to submit them. And so we'll talk a little bit about DUIs and green cards. All right, so welcome. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? Today our theme is it possible to win a green card with a DUI? All right, with a DUI on your record. And, we'll talk about that. And my question for everyone is, hey, do you want to get a green card? Do you want to file for citizenship? Do you want to file for asylum or a U visa or VAWA, or to at least see what the best strategy might be for your situation, or what the best option might be for your situation? Because if so, go for it. And I'd love to help you with that. My firm is on a mission to win 10,000 immigration cases in the next 10 years. And we would love for your case to be one of them, okay? So thanks to everyone for being here. As I talk about this topic, if you have questions, feel free to submit them. I'll do my best to answer them. And welcome to our episode today of the Empowered Immigrant Live, okay? For those who don't know me, my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. I'm also a certified specialist in immigration nationality law, certified by the State Bar of California, and we handle cases throughout the country based out of our Oakland, California headquarters. Okay, so thank you so much for being here. Really appreciate each of you. So we got a lot of news, all right? There's always news happening, it feels like. It's April of 2025. Trump has been back for 3 months. There are a lot of changes happening. Right? ICE is arresting more people. The new registration process has started. Political protesting is considered for deportation proceedings for the first time. I'm thinking for the first time ever, although that might not quite be precise, but for the first time in the last 40 years, right? Programs are getting canceled. All the parole programs, etc., have been canceled. Judges are getting fired. We had a friend of ours was going to a hearing on Friday of last week and walked into the courtroom, and the clerk was crying because the judge had just been fired that day. All right? Crazy, right? So it's not just affecting, it's affecting judges and lawyers and immigrants, and at all levels of the system. It's happening, folks. So something to be aware of. Anyway, thank you for being here. So and when that happens, right? When that happens, any hearing that was scheduled for that day just gets pushed out into the future, and so it's counterintuitive, right? On the one hand, the government is saying they want to deport more people, but on the other hand, they're firing judges. Well, if they do that, they're just causing delays, These cases, they'll be pushed out until 2029, 2030 at some point. Right now, many of our cases are being pushed out till 2027, 2028. But at some point, it's like the process is just going to start taking longer and longer and longer, and that doesn't deport anybody. That keeps people here while they're fighting their case. It's just crazy. It's disheartening at all kinds of levels. So anyway, I wanted to share some of that. So okay, So I wanted to share a little bit about the registration requirement. The registration requirement is live right now. It's been live since the 11th of April. And so the law is saying that if you've never registered before, then you need to do that. And you need to do that through an online account. And they've created a new form, the G325R, and it's online only. And right now, right here, right now on the internet, I am not telling you to register, all right? Instead, I am recommending that you talk with your lawyer about that if you have questions, all right? Many people don't need to do this because many people are already registered, right? If you've ever entered with a visa, a green card, an application, if you've ever been in removal proceedings before, if you had an I-94, a parole document, any of those circumstances, then you are already quote unquote registered, okay? But if you don't have any of those things, and if you've never, if immigration does not know about you at all, then it's like, okay, the best advice is don't just go do it. The best advice is talk with your lawyer about the risks, about the benefits, and about your rights in that program, all right? And that's my best advice for folks. Talk to a lawyer before doing that, okay? Anyway, that's going on. So now to our topic for the day, and I see some folks already asking questions. I really appreciate that. And before we get into it, welcome as always to everybody, whether you're on YouTube, LinkedIn, Facebook, Instagram, or TikTok, like welcome to each of you out there, okay? And thank you for being here. So our topic today is it possible to win a green card even if you have a DUI on your record, okay? And the short answer to this is yes. All right, it is possible. I have won many cases for clients for green cards, even when they have a DUI in the record. And here's the way it works, okay? When a person has a criminal arrest, or when a person has a criminal conviction, those are two different things, all right? That arrest, that conviction will be asked about by the immigration officer. It will be reviewed by the immigration officer. Now, some crimes cause inadmissibility and other crimes do not, okay? A single DUI offense typically does not cause inadmissibility directly, okay? However, there can be some inadmissibility grounds that it's wise to watch out for, okay? For example, if there was a DUI that was charged as a felony DUI, if there was a DUI and someone was hurt or killed, or there was serious property damage, right? Something like that, or if there was also charges for resisting arrest, or there was something else related, or like a hit and run connected with the driving under the influence. Things like that, you know, if anything like that, you want to review those situations and those facts carefully with your lawyer, okay? Similarly, there are health-related inadmissibility grounds where officers, and I've seen this has never happened to one of my clients, but in the DUI context, but it can happen. And, you know, we want to screen people and prepare people because this can happen, all right? There is a health-related inadmissibility ground where an officer could deny someone if they deem or decide or find that a person is a quote-unquote alcoholic, all right? And if the alcoholism that someone suffers from is not in remission and not treated. And when there is a finding like that, what we typically see there is that the officer says, nope, we're not going to admit you, we're not going to approve your green card yet, and go get tested and go do like a rehab program and prove that you're sober for 1 year and then reapply. And so sometimes that can be the situation. Now, typically, that's not what happens if it's a single DUI. But when there's multiple right? Then the government officers look at that, and in the health medical test, everybody has to do a medical exam when they go through a green card process. And those medical officers are trained to ask those questions, right? Does a person have alcoholism, right? And do they, how frequently do you drink alcohol, things of that nature. They also ask about controlled substances, which creates a much bigger problem, all right? That's the other DUI issue. Driving under the influence of alcohol is typically less serious, but driving under the influence of marijuana, driving under the influence of some kind of controlled substance, that can cause a serious problem. That can create inadmissibility. Okay, and so that's what you got to think about. The best advice, whenever a person is applying for a green card, get good advice about it. All right, and talk through all of these things. Even if you have a DUI, you might be eligible to win your green card. You might not be inadmissible, but you still have to meet all the other requirements, right? Just because, even if the crime doesn't make you inadmissible, you might not be eligible yet, right? You still have to, you can't have a misrepresentation, you can't have helped any other person enter the U.S. without permission, you can't have committed fraud any time in the past, you can't have made any false claims to U.S. citizenship or voted unlawfully in the U.S., anything. There's lots of questions to still go through that may have even nothing to do with the DUI and could cause a problem for the case, right? You got to show you have a bona fide relationship to your U.S. citizen spouse or to the person who is petitioning you, etc. Okay? So anyway, typically the answer is yes, it is possible, all right, to win a green card even with a DUI, but the best advice is to still have your lawyer review carefully your criminal record and make sure you're prepared for your green card interview. So just talk it through with your lawyer and get precise advice. Got it? All right. I hope that's useful. I hope that's helpful. I see some folks are asking some questions, so let's get into that. And so, yeah, and in the meantime, thank you all so much for being here. I really appreciate it. Okay? So nature and adventures. I see your question here. You say, those your spouse of to go to biometrics appointment with you. Like, should your spouse go with you to your biometrics appointment? There's no requirement that, well, if your spouse is in your process with you, then, like, if your spouse is, so honestly, if you could talk it through with your lawyer and look carefully at your biometrics notice. But two, typically the biometrics notice is sent per person. All right? And so if your spouse needs to go get biometrics, they should have their own notice. All right? If your spouse wants to go with you, that's typically not a problem. All right? That's typically not a problem. But it is often, to my knowledge, it's never required that your spouse would go with you unless your spouse has their own appointment notice. Okay? Good. All right, Jay, you said you had your I-751 and your N-400 interview last week. You got approved, and now you're waiting for your oath ceremony. All right, huge congratulations. Huge congratulations. Jay, well done. When someone has an I-751 and it's a good case, you bona fide marriage, right? And it just takes forever, and after 1 year that it's pending, file that N-400. And then what happens is often they will both get approved on the same day. And that sounds like that's what's happened here for you, Jay. And so often once the N-400 gets approved, often it's just like a week or two before you get your oath ceremony. All right? And so huge congratulations to you. Well done. And yeah, you're going to be soon to be a U.S. citizen. All right, so congratulations. Let us know again once you are actually sworn in as a U.S. citizen, and huge congratulations to you. All right, I love it. It's great. Okay, so Luna Baby, I see your question here. You say, hola, tengo aprobada el I-130 y el I-212. All right, awesome. So you've got an I-130 and an I-212 approved. All right, and then you say, mandé una moción de reapertura porque tengo orden de deportación. Okay, all right, thank you. And then you say, por ausencia hace muchos años. Okay, I got that. So thank you. Thank you for being here. So you're saying you have an approved I-130 and an approved I-212. That's great. And now you've sent a motion to reopen your removal case. That's great. All right. That's great. I hope, I wish you the best of luck with that motion to reopen. Que tenga suerte con esa moción de reapertura. And if you need any help or assistance with it, I would love to help you with that. Motions to reopen are not straightforward. They are complex, all right? And so, I love winning motions to reopen. I love fighting motions to reopen. I'd love to help you if that makes sense for you, okay? So, sounds like you're going through the right process. And it's important to know if you're here in the U.S., if you're outside the U.S., if you're outside the U.S. or have left, then they won't be able to approve a motion to reopen, but they still could move forward with the I-212 waiver. Okay? So I'll repeat all that in Spanish for you since you asked your question in Spanish. Así que, Luna Baby, gracias. Y felicidades que ya fue aprobada su petición y el perdón, el I-212. Pero ahora si va a someter su moción de reapertura, pues si quiere, y si es un proceso pues correcto, me suena que está en un buen camino, pero que recomiendo si quiere asesoría legal o si quiere representación legal en su moción de reapertura, pues con gusto, ¿ok? Y que puede llamar mi oficina y con gusto podemos revisar las cosas bien y guiarle. Con una moción de reapertura. Esas mociones no son fáciles y a mí me encanta presentar y luchar y ganar ese tipo de moción. ¿Ok? Así que eso. All right, thank you. So let's see. User 4877. Is it a problem if I, the petitioner, forgot to list my children, husband, stepchildren, on an I-751? As long as it wasn't intentional, it doesn't cause a big problem. It does not cause a big problem, but you will want to correct that when you go in for your interview. You'll want to correct that at some point in your case, just to be clear. I mean, you might even, when you get called in for your interview, you might go in with a sheet of paper saying, here's all of my children, their names, their dates of birth, their ages, their locations, whatever, you could look on the I-751 form itself for all of the information. I think it's name, date of birth, physical address. All right, I think it's those things. Confirm with the I-751 form just to be super clear. And you could go in with a paper that you could turn in and hand in saying, hey, I forgot to list all my children. Here they are, right? That way you're correcting that formally on the record, okay? Hope that's useful. Hope that's helpful. All right, so tumbleweeds are real. Hello, Mr. Landerholm. Nice to see you again. It's nice to see you again as well. Thank you for being here, all right? M. Rosas 1318. You say, my brother has a felony and one misdemeanor. He is in rehab in Mexico. Is it to save him to allow him to come back for a DUI? He's in rehab in Mexico. Okay, so maybe he's going through the type of process that I mentioned. So if he was denied and now he's going through rehab, and if they've recommended that at the consulate, then maybe that is maybe that's precisely his situation. I wish him the best of luck. And if you are looking for legal help, and if my office could help you, we'd love to help you. Okay, and but good. Thank you for sharing that. All right, You're not alone. Your brother is not alone. It's a difficult process, and it's stressful to go through that process while you're in Mexico, waiting to see whether or not the consulate is going to eventually approve the reentry. But if you're in that situation, hey, do your best, go for it, and do what you can to maximize your chances of success. Okay? All right, let's see. Tumbleweeds are real. I see your questions here. So, can a family petition be filed with an expired beneficiary's passport? My consulate is giving me a hard time to renew it. Thank you. Yes, the petition can be filed with an expired beneficiary's passport. Yes, but no visa can be put into that passport if it's expired. So file the petition, but you'll need to still take steps to get a valid unexpired passport. Does that make sense? All right, especially if you're going through the consulate. Okay, so good. All right, let's see. Kateksel, thank you for being here. And you say, what if someone was not aware that they must update their address with USCIS? Will this deny the N400? Typically not. Typically not. The best advice is go online and update your address. All right, and then when you're in your N400 interview, you could say, hey, I didn't know about it before, but I went ahead and updated it, right? And you could print out the receipt of that. It's on Form AR11, which is an online form, and you can update your address. Okay? So no, that should not cause your N400 to be denied, but it'd be a good thing to do. All right? If an N400 gets denied for that, you should talk to a lawyer and you should challenge it. All right? Failing to update your address should not be considered anything like, it should not make you a person of bad moral character, which is one of the requirements for citizenship. So if immigration denied it based on that, in my opinion, that would be legal error, and you should fight about that. Okay? But the easiest thing to do would be to go online and update your address formally so that you can explain, hey, you have updated your address. Okay? Very good. User 9112, you say, does USCIS check Medicaid and public health assistance while filing the N400? Yes. If you have Medi-Cal, for example, that's a state program, and that's separate. But when you are filing for a green card, and I believe also for U.S. citizenship, they do ask the question, hey, have you ever requested public assistance? And so you want to be mindful of that, and you can talk that through with your lawyer. I don't know off the top of my head whether or not Medicaid would cause any problem for an N400, but they certainly might ask about it. All right, and I think your question is, does USCIS check that? They might ask you, and I think they put the question on the form. I don't know that it causes directly a problem for the N400. You might have every right to apply for Medicaid as a green card holder, right? So it might not cause any problem for the N400, but it might cause a problem at the green card application stage. And so, talk those things through with your lawyer if you have any doubt or question. Okay? Very good. All right, Joel Cinto, I see you here. Hey, good to see you. Good to see you. I hope you're doing well. Appreciate you joining me here on Instagram. I love it. Let's see, Amy Kahi, I see your question here as well. You say, how long does it take to approve an I-485 based on VAWA? All right. I applied in January. Plus, how long does it take to get travel documents also? These are tricky questions. For VAWA, there's a distinction with VAWA cases depending on if your spouse was a U.S. citizen or if your spouse was a lawful permanent resident. If your spouse was a lawful permanent resident, then it's governed by the visa bulletin. If your spouse was a U.S. citizen, then you are considered a quote-unquote immediate relative, and it's a faster I-485, all right? How long does it take? I would say I would estimate anywhere between 8 months to 2 years, which is a wide range, and it depends on where you are in the country, and it depends on several other factors that are outside of our control, right? And how long does it take to get travel documents? That's typically, 5 to 7 months, typically, as long as the I-131 form was filed with your I-485, then you should be okay after 5 to 7 months or so getting travel documents. Okay? Let's see. J.P. Lopez, C.O. J.P. Lopez, C.O. You say, my lawyer is afraid of requesting ICE to join a motion to reopen as of right now. I mean, there's no reason to be afraid, but they're probably going to deny it. ICE is not joining motions to reopen right now, except in very limited situations. But there's no reason to be afraid of that. Who cares if ICE doesn't join your motion to reopen? You can file without ICE, and you can fight that case and make those arguments in front of the judge. Okay? When you need a motion to reopen, then sometimes that's what you need. Okay? Now, your lawyer might be saying something else. Maybe they aren't super experienced with motions to reopen. Maybe that's what they're saying. Or maybe they're saying, hey, you would put yourself at some risk. Maybe they're afraid for you of filing a motion to reopen because they think that motion would probably be denied. If that's the situation, hey, you might feel free to reach out for a second opinion. In my office, we do lots of motions to reopen. We'd be happy to look at that issue for you if you'd like. All right, that's an option. Or if you are working with a lawyer who's confident, who knows their stuff, who knows the law very well, and you're trusting their advice, you might ask them to clarify. So okay, ICE probably won't join my motion to reopen. What if we just file this to the court? And does the lawyer think that's a good idea or not? Okay. And it's always okay to get a second opinion if you're not kind of on the same page with your lawyer about that, or if you're just not sure, right? It's okay to get a second opinion and talk it through and see if another lawyer might view your strategy differently, right? That's okay. Happens all the time, right? People get second opinions to second guess my legal analysis, and it's good, right? Like, that's great. That's not a problem. It's like lawyers are used to it. It's nothing to worry about. Okay, so Jew V99. You say, hello, my mother has 2 expedited deportations. Can she still get her citizenship? Well, is it possible? Yes. And the question would be how, right? The question would be how. When someone has 2 expedited removals or expedited deportations at the border, what that often means is they've triggered what we call a quote-unquote permanent bar. Okay? So whenever someone has 1 deportation and then they attempt to enter unlawfully again, that triggers 212A9C, which is a permanent bar. The way to waive a permanent bar is for a person to be outside the United States for 10 years and then to apply for a waiver, an I-212 waiver. Okay? And that might be possible for your mother. And there might be other options. Maybe she could get a U visa. Maybe she could, there are other ways to waive the permanent bar. And so, yes, theoretically, it is possible to win citizenship even with those issues. But you'll want to talk it through, right? I'd highly recommend giving my office a call or giving a good immigration attorney's office a call and scheduling a consultation to really talk it through. Okay? I hope that makes sense. All right, so double trouble. I see your case here. You say, I was deported by a judge in 1996, and I came back, and I'm married with a citizen, 3 sons who are citizens. What could I do? All right, well, it's interesting that it was 1996. 1996 is a critical year in immigration law, all right? Because in September of 1996, the law that's called IRA, which is the Illegal Immigration Reform and Immigrant Responsibility Act, was signed into law, and it was actually signed by Bill Clinton at that time. It's a horrible law. All right, it created the 10-year bar, the permanent bar. It created all kinds of problems with immigration laws. And so it would be wise for you, before doing anything, to request your records. Request your FOIAs, compare the dates. Did it happen under the old law or under the new laws? Do you have a permanent bar? Do you not? There might be ways to fix your immigration status. But you might have various bars and things like that. So we should look it through. All right, we should request all your FOIAs, review it carefully, and then we can give you good advice about it. Okay. All right, I'm talking a lot. I'm going to take 5 more questions, and I've got them all right here. And then we're going to wrap up for the day. And everybody, thank you all so much for being here. I really appreciate each of you. All right. So Ray Blanco, I'm going to answer your question. Hello, I am in a adjustment of status through marriage. Can I travel with my I-131, and how long can I be outside the country? I have no criminal record. Yeah, you should be fine. Go ahead and travel. In terms of how long, there actually is no like legal requirement. I always like to say keep it under 180 days. Because that's the best advice for green card holders. And so I like that number, and I think Border Patrol often screens people for that number. But the truth is I've seen people with advanced parole documents that are approved. I mean, without question, you must re-enter before the expiration of your advanced parole document, your I-131 document. Okay, so definitely come back before that and make sure that your passport's unexpired and things of that nature, so that you minimize your chances of having problems with Border Patrol. But otherwise, you should be fine, right? You should be fine. And if you're outside the country, make sure someone is still checking your mail, because if you get scheduled for your adjustment of status interview, you want to make sure to come back into the country to attend that interview. All right? Or your adjustment could be denied for abandonment. So just make sure that people are checking your mail. And if you've got an attorney who's receiving mail on your case too, that's even better, right? All right, K. Escobar 60. What if an applicant worked illegally under someone else's name before applying? So like before applying for a green card. If you are applying through a U.S. citizen spouse, then working without permission is not a factor. It's not an inadmissibility problem. It does not create a problem for an immigration case. All right? However, if your spouse is a green card holder, or if you're applying through a U.S. citizen sibling, or if you're applying through a different like a employment-based immigration case, in any of those contexts, it is a problem. Okay? And so the best advice for you, K. Escobar, is to talk that issue through with your lawyer and make sure you're clear. If you're applying through a U.S. citizen spouse, then just be honest about it and don't worry about it, all right? The key, though, is that you never said that you were a U.S. citizen for the purpose of working, okay? But if you just use someone else's green card, someone else's document, someone else's name for working, that does not cause a problem for your immigration case if you're married to a U.S. citizen. Okay? If you are married to a green card holder, it does. Okay? All right. So I hope I'm clear about that. Talk all those issues through with your lawyer. It's the best advice. Okay. Number 2, I see your question here. Hi, my mother has 2 expedited. Oh, I already answered that. V99. Yes, I already answered that. Can she still get her citizenship? Yes. If so, how long? Talk it through with a lawyer. All right? Right? Because even though it's technically possible to get your citizenship, if it's a permanent bar and if you're wanting to petition for her she would need to be outside the U.S. for 10 years and receive a waiver of those deportations first before being able to enter with a green card. And then after entering with a green card, she would then later, 5 years later, need to be able to apply for citizenship. Okay. All right, let's see here. Edim Marvi. I see your question. All right, I'm not sure which way to read your name there. You've been married to your wife for 5 years. You filed an I-485. You haven't heard back from the embassy for an interview. Well, if it's an I-485, you won't have an interview at an embassy. All right? If it's an I-485, it'll be at a field office inside the United States. If it's a consular process, then the form that you needed to file was called DS-260, and that's the form that would get you in front of your embassy for an interview. Okay? And so maybe there's some confusion there in terms of the process that you're in and which form ought to have been filed depending on your process. If it's an I-485 and you're going to a field office inside the U.S. and you filed it 5 years ago, I mean, you could sue the government, right, at this stage, because that's way outside of normal processing times. You could do what's called a mandamus action, okay? But if you're filing waivers and going through the U.S. embassy or the U.S. consulate overseas, then maybe you're still within normal processing times. So it's a big, that's an important distinction there. Quality cleaning services. I see your question. Does a U visa for a derivative forgive an order of removal? Yes, it can. Does a U visa for a derivative forgive the derivative's order of removal? It can, as long as the U visa filed a waiver to waive the removal order. Okay, does that make sense? So it can, but make sure that that waiver was done and make sure it was done correctly. And but your derivatives U visa will not waive your removal order unless you waived your own removal order. Does that make sense? Each person needs their own waivers for any inadmissibility grounds that they had in their process. So those are important things to be aware of. Okay? Let's see. Divine Queen, you ask, will you get an interview when your child petitions for you? So this is a good question. The answer going forward under the Trump administration is yes. All right? The answer in previous administrations has been sometimes. Okay? And so, I've received information that the Trump administration is going to start requiring interviews on all cases, even in children petitioning for parents. So yes, okay. Linda, if you filed an asylum case and you're appealing a denial and they gave you a deportation, can your son, who now turns 21, file for you? Great question. I love this question. Thank you for asking this. If your case is still on appeal, and if your son turns 21 and they're now petitioning for you, the thing to do is what's called a motion to remand. And you can remand the case from the appeal court back down to the lower court, and you can ask them to adjust your status in immigration court even after the case was denied in the past. Okay? But it's a complex procedure. You're going to want to have some help with that procedure, and my best advice is work with a lawyer who's good and who knows how to file those types of motions in front of the BIA so that you maximize your chances of getting this approved, getting back in immigration court, and getting a green card through your son. Okay? Nice. All right, so Beast Mode Lady. I'm getting a lot of questions. All right, I'm getting a lot of questions. I really appreciate it. I want to address them all. I might not be able to, all right? But thank you all so much for being here. Let's see, Beast Mode Lady. You say, my friend has a U visa pending and needs a test for a very bad condition. She's in pain. I told her to go to the emergency room. I don't know what she's going to do. Definitely tell her to go to the emergency room. All right? Definitely tell her to go to the emergency room. Yep. I mean, people hear on the news, oh, ICE is picking people up at the hospital. In my opinion, in my experience, that's very rare. It's very uncommon. All right? And she's in pain. All right? She's got a medical emergency. She needs to go take care of her health. Full stop, right? Like, we'll deal with the immigration case afterwards. Plus, she's got a U visa pending. So if ICE goes for her, hey, at least she's got some kind of option. You know what I mean? Like, don't worry about immigration. Worry about her health, right? It's like your physical health in the grand scheme of things. If you don't have your health, you don't have anything, right? So it's like, anyway, yes, go to the emergency room. Don't let worry about immigration issues stop you from getting treatment for the things that you need. Right? This is like, forget legal advice. Let's talk about human advice. All right? That's my answer there. Anyway, good luck. Good luck with that. All right, Coyotita75. If you get out of bond and get out of detention on bond, can you marry your fiancé and get legal status? Possibly, yeah. There's no absolutely. Absolutely, if the person's eligible to get legal status through marriage to a U.S. citizen, right? They've got to be admissible, all right? They've got to show that it's a bona fide marriage. It's not just for immigration purposes. You got to ask all the admissibility questions, like why were they detained to begin with, right? All right, Rayil BQ, I see your question here. You say, I am in an adjustment of status through marriage. Can I travel with my I-131? Oh yeah, how long? Okay, I answered that question. Okay, great. Thank you for being here. I see you. Let's see, YOLO9765. Can I file a VAWA case if I experienced sexual abuse from a parent 20 years ago and was sent back to your home country? Your green card expired 10 years ago. Wow, I'm sorry to hear this situation. Really sorry to hear this situation. Can you? I think there's a time limit for children who are applying for VAWA through being abused as children by their parents. And there might be ways around it. All right. Your situation, thank you for being here. You're not alone. Thank you for asking this question. I really recommend you talk to a lawyer. Give us a call. We can look up the answer to your question and see if it's possible to apply for VAWA based on what happened. All right. If your parents were U.S. citizens, if your parents could have petitioned for you but didn't, and you experienced sexual abuse, then it's like, yeah, you very well might be eligible for VAWA. In the alternative, you might very well be eligible also for a U visa if there was ever a report about it. Okay, and if you don't have a report about it, you could potentially make one now, even though it happened 20 years ago. All right, so there's things that you could talk through, and thank you for being here, and thank you for asking that question. All right, I'd love it if you gave us a call and we could really talk through in more depth that situation. Okay, Myra, I see your question. Can someone who has a 13-year-old felony drug case for personal use that has been dismissed and it no longer shows as a case, can they apply and get approved for a green card? It's going to be really tough. All right, it's going to be really tough. Is it possible? Yes, it's possible in theory, depending on how you're getting the green card. But controlled substance issues cause all kinds of inadmissibility. And so if it was dismissed because it was because they didn't prosecute and there was no evidence against the person was quote unquote exonerated, then yes, it might be very well possible. But we'd have to look at why it was charged as a felony. If it was a felony for personal use, that surprises me. But it can happen, all right? But we would want to look at it carefully. Okay? All right, you guys, it's 11:02. I got to get going. Taps Titans, quick question. Why is it taking so long to get an interview now these days? I can't, your guess is as good as mine, all right? Nacho El Gato, 2 arrests for driving with a driver's license, driving without a license before residence. Does that affect citizenship? You've got to include it on your citizenship. All right, you've got to include it on your citizenship, but otherwise, no. It does not. Driving without a license does not cause inadmissibility. It doesn't cause quote unquote good moral character problems. All right, so you should be fine, right? If that's the only arrest. Just U.S. You say, hello, sir. SIV. I did an interview 2.5 months ago. I didn't receive my green card. What should I do? That's common. All right. 2.5 months is nothing, really. All right, in the scheme of immigration law. And so I would say, start worrying if you haven't received your green card after, 120 days, 5 months. That's more common of a timeline. But even then, it's like, okay, once it's a year past the interview, now it's something that you might want legal help about. Okay? JAS1938, you're my last question of the day. You said motion to reopen to the BIA jurisdiction after the asylum case was denied in 2006. You're filing it based on an I-130 pending. You have no crimes. Can or will they reopen? That's going to be tough, Normally with a motion to reopen, you've got to file within 6 months. Okay? Actually, normally you have to file within 90 days, but depending on the type of motion, you can file it up to 6 months afterwards. And normally if it's an asylum related, if there's a changed country condition, changed circumstances for asylum, you got to file that within 180 days of the denial. So now you have a new I-130. Okay, cool. It's possible, right? It's possible. My office has done it. We have one motion to reopen in this context, but it is not straightforward. It is not simple. It's not guaranteeable. So you'll want to really talk it through, okay? All right, you guys, that's all I got for today. Thank you all so much for being here. I really appreciate each of you. I will do this episode in Spanish. I'm going to have to make it super short. I might not have time to take questions in my Spanish episode, but I'll do that in just a moment. I also want to say that if you are a client of our firm, all right, if you are a client of our firm, this afternoon, today, the 24th of April, at 3 p.m., we are having a client call where we are discussing lots of the different things that are going on right now, specifically for and exclusively for our current clients. All right, so if you're a client of my law firm, Land or Home Immigration A.P.C., please join us for our client call, as we always do on the last Thursday of each month, and that is today. We'll see you at 3 p.m. Okay? That's all I got, ladies and gentlemen. Thank you all so much for being here. I really appreciate each of you. My name's Otis Landerholm, Landerholm Immigration A.P.C., where we fight for your American dream. Also, please, if this was useful, if this was helpful, please take a moment, subscribe to our channel in YouTube. All right, we're going for 20,000 subscribers in YouTube right now. Okay, and so we'd love it if you just did a quick search, Landerholm Immigration, in YouTube, and hit the subscribe button, hit the notifications bell, and that'll help us a lot. All right, tumbleweeds are real. Thank you as well. You're welcome, and have a great weekend to you as well. And everybody, hey, make it a great rest of the day. Thank you all so much, and we'll see you next time on our next episode of the Empowered Immigrant Live. Take care. Thanks a lot.